My role this morning was to deliver a judgment which has delayed due to various factors which are highlighted in this very judgment. In that respect, and in the interest of time, I will proceed to deliver the judgment. I will give detailed reasons of why I have declined to hold the delivery of the judgment at a later date. So now I'm proceeding to deliver the judgment. Counsel, can you have a seat? Do you want to protest?
No. I am saying I am going to receive the judgment.
We can put it on record.
That is what I want.
Oh, yes. Thank you, Counsel. We can record that.
I don't want to protest.
I thought it was the street protesting.
No.
That is your right, Counsel. So the judgment I'm going to read is a lead judgment of Alphonse Owinyidolo, Chief Justice. And it also has the concurring judgments of the 4 other members on the quorum, namely Lady Justice Faith Monda, Lady Justice Pasenai Tuhaisa, who is myself, Mr. Justice Mike Chibita, and Mr. Justice Stephen Musota. The lead judgment has 55 pages, but I will not read all of them. I will only select mainly the grounds of appeal and the resolutions for those grounds of appeal, that is, the resolutions and conclusions, and then I will read out the orders. And immediately after that, soft copies of the judgment will be sent to your respective emails. The grounds on which this appeal is founded are: number 1, the land justices of the Court of Appeal erred in law and fact when they avoided to adjudicate the substantial question of illegality, which was the basis of the respondents' appeal before them. Number 2, the land justices of appeal erred in law and fact when they abandoned the grounds of appeal raised by the respondents and irregularly introduced new grounds of appeal that were not implicitly set out in the memorandum of appeal, and thereby erroneously ordered, that is, the striking out of the appellant's amended plaint in High Court Civil Suit number 43 of 2020, and further ordered a retrial on the basis of the original pleadings. 2, that the serving of the order for appointment of auditors, which order had been vacated and was never resurrected in the suit. Ground 3 was that the land justices of appeal erred in law and fact in finding that the respondents were never heard on the question of illegality in miscellaneous application number 654 of 2020 before their joint written statement of defense was struck out and judgment entered for the appellants. Ground 4 was that the land justices of appeal erred in law and fact in failing to evaluate evidence which was before the trial court and setting aside the judgment entered in favor of the appellants. under Order 6, Rule 30 of the Civil Procedure Rules. Ground 5 was that the Land Justices of Appeal had in law and fact in ordering for a retrial of the suit in which the overriding question of illegality had been fully heard and determined inter partes by the trial court. Number 6, the Land Justices of Appeal had in law and fact in condemning the appellants to costs in an appeal where the respondents had not been purged of the illegality adjudged against them by the trial court. Number 7, the Land Justices of Appeal had in law and fact in rewarding the respondents with costs for committing an illegality. Those were the grounds. I'm now going to look at ground 2, which was considered alone. Then I proceed to read. By no stretch, again it is on ground 3, 4, 5, 6, and 7. By no stretch of construction could the type of agent banking provided for in the Financial Institutions Act of 2004 as amended and the Financial Institutions Agent Banking Regulations 2017 made thereunder be applicable to the agency relationship obtaining between the first and second respondents herein. This agency relationship is between a foreign financial entity, that is the second respondent, which is not registered or carrying out financial institution business in Uganda, on the one hand, and a financial entity, that is the first respondent, registered and carrying out deposit-taking business in Uganda, on the other hand. The second respondent is not the type of principal bank envisaged under the 2017 agent banking regulations, since it is not licensed to carry out financial institution business in Uganda. Similarly, the first respondent was not the type of agent envisaged under the agent banking regulations, which only provide for humans operating outlets as agents of financial institutions licensed to carry out banking services. The type of financial transactions entered into between the first and second respondents is otherwise known as syndicated loan facility, which is a global lending phenomenon practiced by local and foreign banks or non-bank lenders. This practice usually stems from the need to spread out and thus reduce the enormous risk associated with lending large sums of money. Individual countries may enact laws that place limits on the amount of money a bank can lend to a single borrower, thus encouraging syndicated lending. See, for example, Regulations 6, 9, 10 of the Financial Institutions Limits on Credit Concentration and Large Exposures Regulations of 2005. With these restrictions, large entities constantly looked for foreign financial institutions, which may be banking or non-banking institutions, for syndicated credit facilities. I will now proceed to the part of the conclusion and the orders. As is discernible from the analysis above, the rights and roles of the agent appointed in the agency relationship provided for under the Financial Institutions Act of 2004 as amended, and the 2017 regulations made thereunder differ markedly from the ones conferred on the agent appointed under the syndicated relationship. The duties of the agent in the syndicated relationship are much wider than that conferred on the agent provided for under the Act and regulations made thereunder. Most notably, a financial institution in the syndicated credit facility arrangement, which is appointed an agent of the other creditors in the syndicate, remains at par with them, because it is, in its own right, also a creditor to the same borrower, which is precisely the case herein. In the instant case before this court, the second respondent is neither licensed nor regulated to carry out financial institution business in Uganda. Hence, its appointment of the first respondent as its banking agent could not have been so done under the provisions of the Financial Institutions Agent Banking Regulations of 2017. The first respondent, being an entity duly licensed to carry out financial institution business in Uganda, could not have been appointed a banking agent of the second respondent within the purview of the Financial Institutions Act of 2004 as amended, and the Agent Banking Regulations of 2017 made pursuant thereto. Accordingly then, the relationship between these two banking institutions and between them and the appellants with regard to the financial credit transactions carried out between and amongst them were neither governed by the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations made thereunder. In the syndicated agency relationship created between the first and second respondents as banking institutions, the rights and duties conferred on the first respondent as the agent bank in the relationship between the two banking institutions makes the first respondent a fiduciary to the second respondent. The amendment of the plaint, which introduced the claim of illegality as a cause of action, was proper in law. Number 2, the syndicated credit facility executed between the second respondent and the first appellant, with the first respondent as agent of the second respondent, is lawful, and neither the Financial Institutions Act of 2004 as amended, nor the Financial Institutions Agent Banking Regulations apply to them. Number 3, accordingly, The claim impugning the legality of the credit facility contracts between the parties hereto is disallowed. Number 4, the issue of illegality having been resolved in this appeal, High Court Civil Suit number 43 of 2020, between the parties hereto, which was the genesis of this appeal, which was the genesis of the appeal to the Court of Appeal and ultimately to this court, is remitted back to the High Court for trial before another judge, basing only on issues of fact arising from the pleadings. The respondents are awarded 50% of the costs in this court and in the Court of Appeal. Since the other members of the quorum are in full agreement with the judgment and orders, I have proposed above judgment and orders accordingly hereby given in the terms stated out herein, dated this day of June 2023, Alphonse Chigamoy Owinyidolo, Chief Justice, signed. Then there are 4 concurring judgments, as I had stated earlier, of Justice Faith Monda, Justice Passet Haise with myself, Justice Mike Chibita, and Justice Stephen Musota. They are all duly signed.
We have received the judgment, and the Supreme Court, in its own wisdom, has directed that we should not talk about the issues of illegality, even in the High Court, which we think is wrong, because as you have seen, we had applied to this same court to adduce evidence of illegality. But the Supreme Court has refused and has said, don't talk about that. Go back to the High Court and talk about matters of facts, whether there was a loan or what. And we are not happy with the decision, but we accept it. We shall go back to the lower court and argue.
So what can you solve that issue that they are saying they are governing financial issues? They don't.
In fact, the Supreme Court has confirmed that the transaction was illegal because it is not supported by law. But they say, since it is a syndicated loan, which the same court has not quoted any law supporting it, that it should go ahead. So we have no problem. We shall go and argue our case. We are just beginning.